The Texas legislature is debating whether or not to reform tort law, the law that applies to damages in a civil suit. The House has already passed its version. The Senate's considering it now, and if it approves some version of the bill, there will be a conference to work out the details. Not surprisingly, the legislation has engendered considerable debate. The tort reform bill plans to change the state's damages laws in such a way as to limit non-economic damages to $250,000. Among those opposed to the law is a group of both defense and plaintiffs' lawyers called Texans for Civil Justice. We have the president of the organization with us today. Jeff TIllotson is senior partner with Glen, TIllotson and Pinker. He specializes in complex multi-party commercial disputes, class actions, and securities matters, and has represented many Fortune 500 companies in consumer class action suits, fraud cases, and breach of contract suits. He earned his J.D. with honors from UT after receiving a bachelor's in foreign service from the Georgetown School of Foreign Service. Tort reform has its fans, of course. One of them is Jim Copeland, the director of the Center for Legal Policy at the Manhattan Institute. He was educated at Yale Law School and School of Management, where he was an Olin Fellow in Law and Economics. The center has been a leading voice promoting tort reform. This year, one of its senior fellows, Walter Olson, published The Rule of Lawyers, which alleged that plaintiffs' lawyers have assumed the role of a fourth branch of government in shaping public policy. Later this year, they plan to publish papers on mass action tort claims in Mississippi, medical malpractice, and what the group calls the industry of class action litigation. If you want to talk with my guest today, we're at 214-871-9010 or 1-800-933-5372 or GMS at KERA.org. And because we always keep telling you what a smart audience you are, and you can keep multiple things in your head at the same time, I will mention one more time that pledge number, which is 1-800-456-KERA. 1-800-456-5372. So please call that number and pledge. Jeff Tillotson, welcome.
Thank you. Good afternoon.
And nice to have you with us, Jim Copeland.
Thank you.
Could each of you characterize what you think this legislation is designed to do and will do? Jeff, you want to go first?
Well, it's designed to put limits on lawsuits in a way that would be productive for both consumers and businesses. That's the goal. Whether it actually accomplishes that or goes too far to limit what would be meritorious claims, I think, is the debate.
Mm-hmm.
But the idea is to bring some sanity into the litigation form and allow people to have their fair day in court without getting an advantage either way.
Mm-hmm. Jim?
Yes, I agree. I think that's really the purpose of the legislation. I mean, the omnibus bill that's pending really involves a lot of changes to the law, both substantive and procedural, that we have been advocating for some time here at the Manhattan Institute. Texas, I mean, the U.S. system generally for tort costs is far more expensive than that of any other developed nation, over 2% of our GDP, over $200 billion a year. Texas particularly stands out as being a very difficult environment in the tort arena and being a very costly environment, a very pro-plaintiff environment. The American Medical Association listed Texas as one of its tort hellholes. Of the 11 jurisdictions that the American Tort Reform Association focused on as tort hellholes, 4 of those 11 are counties in Texas. And what you have happening is trial lawyers shipping around looking for the easiest jurisdiction, the county with the most permissive judge, and launching massive national cases in those jurisdictions in Texas, which obviously puts defendants in a very difficult position when you're able to just shop around for the most permissive jurisdiction that's out there. And these defendants with the massive dollar volume on the table often have to settle cases because they can't risk bankrupting their company and losing the case. So the variety of provisions there would prevent the worst of these abuses, and that's why the bill is a good idea.
Jeff, what are you worried about regarding this legislation?
Well, the concept itself of putting limits on lawsuits in a way that's productive and practical is a good one. The only question is how you do it. What my group, Texans for Civil Justice, has become concerned about is the hodgepodge nature of the bill, which is a collection of essentially special interest ideas in ways to limit lawsuits that benefit a particular interest group without regard to whether or not it's fair and will make lawsuits themselves fair. I don't think anyone in America seriously disputes the notion that out there are frivolous lawsuits. However, no one can also seriously dispute that there are many, many, many meritorious lawsuits where people need their day in court. And the idea is to make it so it's fair. And the problem with the current legislature that's been proposed, House Bill 4, and cleared the House and now currently being debated in the Texas Senate is that there's been no study or rational thinking as to what changes in the law make sense and whether the changes that are currently being proposed would be fair. And as we get into it, you can see some of the details of it. But I think the main concern that many lawyers have, both on the plaintiff side as well as on the defense side, is that this bill unfairly tilts the wheel towards certain people in lawsuits, and that meritorious claims will be left on the cutting room floor of the Texas legislature.
Tilts them to?
Well, for example, the most well-known and controversial portion of the bill is that it caps damages for pain and suffering in any medical malpractice case at $250,000. It also contains a provision that would allow the legislature to ultimately cap non-economic damages in any lawsuit at $250,000. I can tell you from 15 years of litigating, the one thing I can say is I've never seen two lawsuits alike. And many lawyers around the state are concerned that we can say now, today, with absolute certainty, that there's no lawsuit out there where a plaintiff, an individual, a housewife, a father, a child, wouldn't be entitled to more than $250,000 in non-economic damages. That's one concern. There are many other broad changes in the law that people haven't really realized the effect of. There are changes in the product liability law in Texas that would essentially have eliminated cases against Firestone for the tires and other companies and may render consumers subject to products that are unsafe with no remedy in court. There are substantial changes to the class action provisions of it, which I think well-intended could have the opposite effect of making class action lawsuits more difficult and cumbersome. Those are just some of the changes, and there's been no study, no analysis as to whether or not these changes in the law would be effective for consumers or businesses.
Jim, what about that? Are we going after a mosquito with a sledgehammer with this legislation?
Not at all. I mean, first of all, the claim that there are no studies is simply false. Although we haven't done studies for Texas specifically, with the exception of focusing on the magnet court problem I articulated, where we published a study a couple of years ago focusing on Jefferson County, Texas, as one of the national magnet court jurisdictions where these claims all nationally flood to. We've done a number of studies to buttress a lot of these ideas. I mean, for instance, I mean, the only specific unfairness that the other side keeps pointing to is the $250,000 medical malpractice cap. But in fact, a lot of these provisions, the class action provisions, are pretty standard ones. In other words, what are we proposing to do here in this class action reform section of the bill? Providing for interlocutory appeals of a class action certification to the Texas Supreme Court. Interlocutory appeals are common in other states. The federal court system has an interlocutory appeal. Now, what exactly is an interlocutory appeal? What that means is that when the local judge makes a determination that this class is appropriate for a class action, you can appeal at that point that determination. Why is that important? Because if you have a large class action lawsuit against a defendant, you can be talking about hundreds of millions, indeed billions of dollars, and the defendant is forced to settle once that class is certified, because if not, the defendant may be bankrupt by a potential verdict against it, even though the defendant may have a 90% chance of winning the case. It may be a frivolous case. The defendant's going to have to settle because no CEO is going to take the risk, even if it's a fairly small one, of bankrupting their company by pushing forward to trial. And then, you know, the other provisions, again, are determined to, in the class action context, limit the abuses of the system. One of those is requiring the fees to class counsel to be calculated by a lodestar method. Very common in other areas of law. What you really have happening here in the contingency fee system is the plaintiff's lawyers get a percentage take on the lawsuit if they win. What's the problem with that approach? It seems like, they're able to assume the risk. Well, if in fact there's a claim that has a low probability of success but a potentially high payout if it's successful, a plaintiff's lawyer has an incentive to take that case. So if you have a claim that you think is worth $10 billion if you succeed, but you only have, say, a 1% chance of success, it's pretty much a frivolous claim, you still are going to be willing to spend up to $100 million pursuing that claim if you're risk neutral. And so what you have happening is plaintiffs' firms taking bad claims, and what this type of reform would do is, in fact, make the incentives such that frivolous claims would no longer be taken.
Okay, well,
another provision on the class action.
Hold on, that's a lot to deal with. Let's get a response for you first.
Well, let me start first with one of the basic points about my organization's view on the bill. If this bill simply said that the Texas Supreme Court gets to automatically review cases that are certified, then I don't think there would really be serious opposition to just that provision. The way it works now, so your listeners understand, is a case is certified by the trial judge. The defendant has the right then to appeal that to the Court of Appeals. The Texas Supreme Court, at its discretion, may consider it, but it doesn't have to. One proposed change would be to require the Supreme Court to review those cases to provide an extra measure of review. That wouldn't be the problem. But the bill doesn't just stop there, because the real goal is to make class actions so unappealing to anyone that they won't be brought. That's where the notion of limiting lawyers' fees comes in. And another provision, which I don't think any other state has this particular provision, which would require any class action filed in Texas for which any regulatory agency in the state has any jurisdiction over, that case would automatically be stayed and sent to that particular agency. Even if the agency didn't have the power to address the problems, and many of them don't, and moreover, no money has been allocated to our agencies to review those problems. It's a clever way to simply ship class actions off into the deep freezer for a few years and hope that the case goes away. I will point out, one thing is that we're not the other side on this. Part of my organization is lawyers who represent companies in class actions as well as plaintiffs in class actions. And I will tell you that in years of litigating, it is rare to see defendants pay millions of dollars for knowingly frivolous claims. It sounds good. It rarely ever happens. And we shouldn't tinker with the class action system to eliminate class actions, which can be a valuable source of relief for many people, without seriously thinking about whether or not we're wiping out claims. Keep in mind, although class actions have a bad name, if a company is knowingly taking away $10, $15, $18, $20 from each of its consumers through, say, some sort of fraudulent scheme or whatnot, very rarely would any individual consumer spend more than 10 seconds to address that problem. And the idea behind class actions is that we aggregate those. We can put consumers on an equal footing with businesses. I agree with many of the things the Manhattan Law Institute says, that has potential for abuse. The problem is that taking away that right in its entirety from consumers gives companies an equal potential for abuse. And the idea is, let's level the playing field for class actions. And I might point out, because most people don't really have any experience with class actions except for settlement notices they might see in the mail, class actions are extremely difficult cases to pursue. The certification process can take years, requires a tremendous amount of resources, and there are extremely stringent requirements to have a case certified in Texas. Over the last 5 years, out of maybe the 40 reported opinions in state courts on class actions, only a handful, 4 or 5, have actually been upheld as being certified by the Court of Appeals and subsequently the Texas Supreme Court. So there are measures in place for that.
We have to take a break in about 2 minutes, but I'm going to let my guests take a little break here. I'm going to ask you to be patient and get in line with your questions at 1-800-933-5372 or 214-871-9010 if you have a question for Jim Copeland or Jeff Tillotson. I'm going to ask the rest of you, however, to give me your undivided attention unless you're calling or getting online to pledge, because that's what I need you to do right now. We have a fairly ambitious goal of 75 new members or renewals for this show today. Any amount will do. $35, wonderful. $1,500, great. But please don't put it off. Again, 75 is a lot to get in one show. We have 53 to go and only about 35 minutes to do it. This is your chance to do the right thing. If you want to pledge at the $35 level, you can get the member card, which gets you into our movie screenings for free, gets you discounts or half-price tickets, 2-for-1 tickets at arts organizations and events all around the North Texas area. That's a $35 membership. It's not a bad deal. If you want to pledge at the $200 level, we'll throw in a pair of tickets for Tour of Taste on May 9th at the Fairmont and a ticket for the raffle for the Lexus. Definitely not a bad deal. If you'd like to go the $240 route for the KERA on-the-go package, We'll set you up with more 90.1 stuff than you can use probably in a year. If you want to be a day sponsor at $365, that's grand. If you want to pledge at the Friends level for $1,500, better still. And let's face it, as I said yesterday, if you can go $1,500, what's $2,000? Pledge the extra $500 and you'll get a pair of tickets to a dinner with Jacques Pepin at Abacus coming up in May. These are all different ways that we have of saying thank you for doing what you need to do in the first place. So please don't put this off. Listening online costs money, but that's not free. If you want to pledge, if you use that service, just think of it as paying for your online listening service. If you want to call us up and use your credit card, that would be swell. Put it on your credit card. Send us a check. We'll make it as easy as possible for you to pledge, but it really does come down to memberships paying for the radio station, $35, $60, $120 at a time. Sometimes we get lucky. We get a $365 pledge or a $1,500 pledge. The fact is, somebody thinks, $35 is not going to help keep a radio station on the air. $60 isn't. And that's true. But when you get 500 of them or 1,000 of them or 2,000 of them, all of a sudden that starts to turn into real money, and the radio station's financial health starts to look better. So that's why we do this. It really is up to you. It really is important that you do it. Again, we took a risk booking 2 interesting hours today. We could have done boring shows. Then you would have been more inclined to go to the phones because you figured, well, I'm not going to miss anything on the air. We'd rather not do it that way. We'd rather try to keep up the high quality of programs that we always try to put on the air, and just hope you'll tear yourself away for 60 seconds or 120 seconds to pledge, which is why I'm giving you this little window of opportunity to do just that. We're under 50, but we're also down to about 30 minutes to get our goal for this hour of this show, of 75 new members or renewals. We're going to come back in a second. We'll talk with Jeff Tillotson and Jim Copeland. We will take a break right now and be right back. But while we're doing that, why don't you call or go online and pledge 1-800-456-KERA or KERA.org. We'll be right back.
KERA would like to thank Burger Street for donating the lunch for our volunteers and staff today. Burger Street is locally owned and features third-pound hickory-seasoned hamburgers. Lunch was catered by the Mockingbird and Greenville restaurant, one of 15 Burger Street locations that cater to businesses, schools, and churches. Thank you, Burger Street, for your support of KERA.
Coming up today at 2 o'clock on the world, the U.S. is pulling out its military forces from Saudi Arabia. Thailand tackles SARS, and how SARS is affecting adoptions from China. Those stories and all the day's top news coming up today at 2 o'clock on the world. One more time for pledging, it's 1-800-456-KERA or pledging online at KERA.org. And if I could get a bit of assistance from my friends down the hall, if you could give me the date of the Jacques Pepin deal at Abacus. That's coming up on, shuffling through those papers, desperately trying to find it, on May 12th. So anybody who's thinking about that, pledge the normal $1,500 Friends pledge. Just bump it a little bit. Make it $2,000 and go to that deal on May 12th. If you want to talk with us right now, 1-800-456-KERA that's the pledge number. You can call us to talk at 1-800-933-5372 or 214-871-9010. My guest by phone, Jim Copeland, director of the Center for Legal Policy at the Manhattan Institute. Here with us in the studio is Jeff Tillotson, who's president of Texans for Civil Justice. We're talking about the Texas legislature's debate over tort reform right now. The House has passed a version. The Senate's thinking about it right now. Let me ask, Jeff, I want to start with you on this. You argue that this legislation is sort of a pro-defendant laundry list that attacks the rights of citizens. You usually represent defendants, if I read your bio right. How come you aren't sort of happily pleased by this?
Our practice at my law firm is both plaintiffs and defendants, so we have a even balance of the kinds of things we do. That said, when you look at making changes into the law, you look beyond just simply what might benefit a particular client on a particular case, and you look at what's best overall, because as lawyers, you never know who you're going to wind up representing and what you're going to be arguing, and therefore most of the lawyers as part of my organization are more interested in ensuring that the rules are fair, whatever side of the docket they're on.
And Jim Copeland, we're supposed to believe in jury trials and the wisdom of juries. Won't your arguments short-circuit